The Supreme Court today asked the centre why it cannot call for an all-party meeting to determine issues pertaining to freebies promised by political parties during the elections. During the last hearing, the court, while acknowledging the complex nature of the issue, had stated that the intention of the court is to initiate a wider public debate on this issue, and it is for that purpose that the constitution of an expert body was mooted. To provide a brief context, the Supreme Court was hearing a public interest litigation petition filed by BJP leader Ashwini Kumar Upadhyay seeking directions to the central government as well as the Election Commission of India to take steps to regulate poll manifestos of political parties and make political parties accountable for the promises made in such manifestos. On August 3rd this year, the court had opined that an expert body consisting of various stakeholders such as the Niti Aayog, Finance Commission, Law Commission, Reserve Bank of India and members of the ruling and opposition parties would be required to give suggestions to address the issue of promise of freebies during election campaigns. To enable the court to pass an order on the constitution of such an expert body, the Supreme Court had directed the petitioner, the central government and the Election Commission of India to give suggestions. However, subsequently, the Election Commission of India had taken a stand before the Supreme Court that it is not within its mandate to regulate the policies which a party might adopt after getting elected. In a supplementary affidavit filed before the court, the Election Commission declined to be a part of the expert body proposed to be constituted by the Supreme Court to examine this issue of freebies by stating that it is a constitutional body and therefore it cannot be a part of such a body. However, subsequently, the Election Commission of India had taken a stand before the Supreme Court that it is not within its mandate to regulate the policies which a party might adopt after getting elected. In a supplementary affidavit filed, the Election Commission had declined to be a part of the expert body proposed to be constituted by the Supreme Court to examine this issue of freebies. It had also averred in the supplementary affidavit that it is a constitutional body and therefore it had expressed its unwillingness to be a part of this proposed expert panel. On the last date of hearing, the court also pertinently took an unfavourable view of the comments made by the DMK party representative on television debates regarding the Supreme Court hearing the case on freebies. Tamil Nadu Finance Minister Palanivel Thiagarajan had said on a TV debate that there was no constitutional basis for courts to enter into the domain of economic policy. So what exactly happened today during the proceedings? At the outset, senior advocate Vikas Singh, appearing for the petitioner, stated that according to him, a retired judge of the Supreme Court such as Justice Lodha should be the chairman of this expert committee proposed to be constituted to study this issue of freebies. In response, CJI Ramana commented in a lighter vein that a person who has retired or was going to retire has no value in this country. The hearing also saw Advocate Prashant Bhushan appearing for the Centre for Public Interest Litigation, Endeavour, to define the term freebies by arguing that there existed three kinds of freebies which were illegal. First, the ones which violate fundamental rights. Second, the ones which were violative of public policy and are given to corporations among other things, even though such bodies are guilty of willful loan defaults. And third, pre-poll freebies, which as per Advocate Bhushan is like bribing the voters. He also stated that freebies promises right before elections, such as 6 months before the polls, is also problematic. Senior advocate Kapil Sibal on the other hand argued that political parties don't have access to financial records of the state before getting elected to office and thus expressed reservations about the proposal that they should disclose the source of funds for promises in their manifestos. Sibal argued that the solution lies in implementing the Fiscal Responsibility and Budget Management Act of 2003. He stated that if the deficit exceeded 3%, the Finance Commission could look at it and the allocation could be reduced from the next year. Solicitor General of India Tushar Mehta during the hearing today highlighted that there are parties who may not be in power but are nevertheless rolling out promises to influence the voters unduly. He highlighted this issue with an example, and I quote here, "For example, someone says, for all of you, I will not charge electricity. People can be lured. I don't even know from where the money will come. Electricity is one example. Would the voter have an atmosphere where he can take informed decision? Can you promise the moon to get elected?" At this juncture, the Chief Justice of India asked the Solicitor General as to why the Government of India is not calling for an all-party meeting to discuss this freebies issue. In response, the Solicitor General stated that political parties have already approached the Apex Court opposing the promise of freebies, and thus in this very background, an all-party meeting may not be productive. He also remarked that there are some political parties who think that it is their fundamental right to offer freebies and have come to power by only offering freebies. At this point, CJI Ramana lamented over who would head the expert committee if the Supreme Court constitutes one, and also underscored that it is important to have a debate on this crucial issue as freebies can destroy the economy and that a blanket order cannot be passed in this regard. CJI Ramana remarked, and I quote again, "Biggest problem is who will head the committee. Ultimately, it is the political parties which make promises and contest elections, not individuals. Suppose if I contest, I won't even get 10 votes because individuals do not have much importance. That is how a democracy is. Who is in opposition today can come into power tomorrow, and so they will come and have to manage this. So things like freebies, etc., which can destroy the economy, has to be looked at, and I just cannot pass a mandamus. Thus, there needs to be a debate." Senior advocate Dr. Abhishek Manu Singhvi, appearing for the AAP government today, took objection to the Solicitor General's statement that voters can be lured by freebies, and accordingly commented that it is wrong to think the voters of the country are gullible and that they can be fooled, and that the country had universal adult suffrage even way back in 1947 when our literacy rate was merely 12%. Senior advocate Arvind P. Dattar, who had appeared in the Subramaniam Balaji vs. State of Tamil Nadu case, submitted that the 2013 decision of the Supreme Court needs reconsideration. In that judgment, the Supreme Court had held that promises made by political parties in the election manifesto would amount to corrupt practices as per Section 123 of the Representation of the People Act. The court had also held that the Comptroller Auditor General of India cannot dictate how governments spend their money, and that the court cannot make guidelines or laws on what election promises should be allowed. Dattar also wondered how offers like fridges, televisions, grinders, gold chains, etc. can be regarded as welfare measures. He submitted that the Subramaniam Balaji decision had made an erroneous ruling that an offer made in an election manifesto cannot be regarded as a corrupt practice. Appearing for the Election Commission of India, senior advocate Maninder Singh also argued that the judgment of Subramaniam Balaji vs. State of Tamil Nadu should be reviewed, as the judgment states that the directive principles of state policy could control fundamental rights enshrined in the Constitution. Pursuant to such voluminous submissions, CJI Ramana indicated that a bench might be constituted soon to reconsider Supreme Court's judgment in the Subramaniam Balaji vs. State of Tamil Nadu case. Thank you. This is Aratroka Bhaumik for LiveLaw. Please do not forget to like and subscribe to our YouTube channel for more such updates. Also, let us know what your thoughts are on this issue of freebies in the comments below.